What's up, everybody? Welcome back in to another episode here. And we have a bit of a doozy, something I wasn't sure we were going to get much of before the trial, but Lori Vallow is in court representing herself and making arguments with her own mouth, discussing the issues she has with this case, with the evidence or lack of evidence, and how the state and maybe law enforcement are all conspiring against her and what they're doing that is unfair. And maybe we start to see what her legal theory is in the trial, that she's going to go forward and argue herself, her own case to the jury. So let's get into it. So a lot of what we're going to discuss in today's video and what they discuss in the hearing is potential discovery violations. Is the state violating Lori Vallow Daybell's rights? Are they not turning over things? Are they hiding things? And what arguments does she make? And we're going to listen to these arguments and try to figure out how much help is she getting, if at all, from her standby counsel. Is she doing this on her own? What can we expect at trial when she represents herself?
Inmate Legal Services works. Did you receive the state's response yet?
I did receive it yesterday, but I was hoping that I could put my response on the record today, my reply.
That's fine. Go ahead.
By the way, the first thing I'll notice is she said, I did receive it. She seems very confident in how she speaks. And she also says, I want to give my response orally today. And then she calls it a reply, which is technically correct and the proper thing to call it. She files the initial document, the state responds, and then she replies to that response. Learning some terminology here.
Ready?
Yeah.
Okay. Oh, I get my glasses.
She's like, I got to get my glasses. People are, I can't wait to read the comments on her disposition and how she is in this hearing and what the jury is going to think when they see her making these arguments in front of them. Right now, not in front of a jury. It's pre-trial. She says there's like 70 days until her trial. So all this stuff is just in front of a judge and these cameras.
Do you want me to stand, Your Honor, or can I just sit here?
You can sit there.
So the state has claimed in their response that these documents are not material in the case, and this defense is entitled to this specific evidence for the proposition that this evidence can be used to impeach the thoroughness and good faith of the police investigation and the intent of the prosecution. That's Kyles versus Whitley, 514 U.S. The acid test.
So she is citing case law, explaining that why she would be entitled to this evidence, whether it's probative or impeaching or shows a lack of a thorough investigation, which are all things we've seen defense teams attack in prosecutions and investigators and law enforcement in other cases. We'll get to exactly what she's talking about and what she wants a little later in the video.
Test of this prosecution is not a matter of determining if the defendant is guilty of the crimes that the defendant is charged, but rather, was any crime even committed? And where is this evidence? This defense has yet to find any evidence of a conspiracy in the 100,939 pages that have been turned over by the state.
So she's about to make a very good argument that just because you turn over 100,000 documents or 100,000 pages doesn't mean you've turned over everything, number one. Doesn't mean you've turned over everything that's important. Doesn't mean you've turned over everything that the defendant is entitled to. Those are all very good arguments that she's about to make. The problem in her verbiage is she says, we, the defense, has looked through these 100,000 pages and we see no evidence of a crime and no evidence of a conspiracy. It's like, well, just because you don't see it doesn't mean it's not there.
The state does not get to say, like they did in their last motion to us, in their last answer, to say, oh, we gave you over 100,000 pages, so that ought to keep you busy. That's not how it works. These are serious charges, and these are serious consequences for these charges. In determining the actuality of a crime, the state is required to meet, in reality, not in theory, a standard of culpability that is defined by law as a crime. The state is required to meet the challenge of defense reasonably without bias, conflict, prejudice, or speculation. So the defense, we keep filing motions for discovery since we don't know if it's some kind of strategy of the state that they're holding back this actual evidence of conspiracy in hopes that the defendant won't have time to prepare a proper defense against the evidence that comes forward at the last minute. This court has denied every motion the defense has filed to acquire this evidence. The state has claimed in their response to the defense's motion that the defense's request is overbroad and wide sweeping. Is this the defense left to pinpoint where this evidence is and try to find it? No, that is not the law. The state is required by law to give the defense evidence of the crime they are being charged with. This is the purpose of the.
So a couple things she said there. Basically, it sounds like, the judge keeps denying our request. You got the judge and the state and the law enforcement all against her, working against her. Are they is this just a theory or a tactic of the state to delay and not turn everything over till the last minute so that she can't take the time to defend herself and respond? Again, arguments we've heard in prior cases as well. I don't really know what I was expecting, if I'm being honest, of how she would act and defend herself and speak and what her kind of style would be. Would she be confident? She's, written it all out and is somewhat reading and somewhat looking up and arguing, but it's very coherent. It's cogent. I disagree with many of the arguments she's making as far as, the fact that she can't see where the evidence is of the crime means that it doesn't exist, as opposed to the correct argument is they turned over everything, so they better not be bringing something later, Judge. They better not turn something over at the last minute. This better be all they have, because I don't think it's enough to prove a crime, but if this is all they have, go for it. Let's go to trial. Let's see what happens. But I don't want them bringing stuff up in evidence or trying to enter things into evidence during the trial that they haven't given me yet. That's the proper argument, is that I don't want any late disclosures, Judge. We're asking for all of this now. They said they've given it to us. It better not change later. And if it does, it should be struck. That's really the argument she's looking for when she's saying there's no evidence here. Because as a defense attorney, if there's no evidence of a crime, it's like, we can win this case. Let's go forward. Let's beat them. She's saying, give me the evidence, because right now I don't see any, so it's like, but she's saying it very confidently. She's stringing it together. And there's a portion of this hearing where she starts responding to the judge that, again, I think it's better than some other pro se defendants we've seen. I'll say that.
The Brady Law and the right to due process. This is why in 2020, the United States enacted the Due Process Protection Act that provides defendants like me with greater protection, Brady versus Maryland. The state has continued to impede the defense from conducting a defense. This is a violation of the 14th Amendment of our great Constitution and the defense's due process rights. Today, the defense is requesting that this court do the following three things. One, order the state to turn over all evidence of a conspiracy since our trial begins in 76 days from today. I would also
76 days, they're going to trial. So I don't know what the deadline is for discovery in this case, but usually it's coming right up. And sometimes it's 90 days. Sometimes it's 60 days. In certain circumstances, they make some exceptions and let you continue to do it up until trial. But she's filing all these motions, and you're going to hear a couple motions she filed later for more discovery, more specific discovery, turn it all over.
Also asked that they would pare down their witness list to these witnesses that will actually be testifying so the defense can conduct productive interviews.
That's a fair question and request. Again, not how the legal rules work. They don't have to. When there is a pro se defendant, though, some judges will force the state to do some things they don't normally have to do. And for example, they can maybe come up with 3 lists: who we're for sure going to call, who we think we might call, and then who we're not going to call. But they don't want to be held to that either, because that's the point of the witness list, is you can't call somebody that's not on it. So we usually, as lawyers, have a lot more people on the witness list than who we're actually going to call. So asking us to pare it down, as long as there's an understanding that, Judge, we do have the right to call these people, and we're telling her, here's everybody we could possibly call. If you want to do the interviews, do the interviews. Because the state has a right to do their trial the way that they feel is proper and correct to seek justice as well. Today's sponsor helps with one of my biggest pet peeves, and that's getting rid of unwanted subscriptions, even sometimes after you think you've canceled, but they continue to show up, whether it's on your bank account or your credit card charges. And as someone who thrives on keeping things very organized, that frustrates me to no end. And that's where Rocket Money comes in. Rocket Money is today's sponsor, and they're here to help you take control of your finances. Rocket Money is an all-in-one personal finance app. It helps you manage subscriptions, lower bills, create custom budgets, and even grow your savings all in one place. For me, the subscription management feature is a game changer. After connecting your bank account, Rocket Money identifies all your subscriptions in a single list. Canceling the ones you don't need anymore is as simple as a few taps. No customer service calls, no hassle. This number may actually shock you because Rocket Money has already helped its users save over $500 million by canceling unwanted subscriptions and negotiating bills. Imagine what it could do for you. To try Rocket Money for free and unlock more features with premium, head to rocketmoney.com/LYK or click the link in the description below. So take control of your finances today with our sponsor, Rocket Money.
And then I would like for all motions and responses to be sent directly to the defendant in a timely manner. I'm having a really hard time getting this stuff. I don't get it from ILS to 7 days after things have been filed, after your orders have been rendered. I'm not getting these. This defense intends on starting trial on time without delay. And I request that also that this defense requests that the court grant the motion to order the state to produce all discovery of extradition at this time so that we can get started on getting prepared for trial.
What does the
So, and one of the things she's really asking for in this motion is information on the extradition from Idaho to Arizona. And that's kind of where we're like, why do you need the extradition information? Is there something going on? Maybe we don't know. And that's a big question the judge has. Like, why do you need the extradition information?
anything in the extradition have to do with the underlying charges? Can you tell me that?
Yeah, it's to find out why all this started when I can't find any evidence that there is.
Have you
So
read the grand jury transcripts?
I have.
Okay, the grand jury transcripts summarize what the state's evidence they intend to produce at trial.
I understand.
So the judge is like, why is that relevant? She's like, it could be relevant. She's going to go back and forth with the judge here for a second. But he's like, you've read the grand jury transcripts, right? That's the state's case. That's the summary of the state's case. There might be more, there might be less, might be different witnesses. But generally speaking, you know what evidence is the state is going to present. And again, you can continue to do these interviews and continue to learn what the state's going to produce. But it's not like you don't have anything. And I'm still not following why you need the extradition information.
Done that.
So when you say you can't find anything, that is the summary in the grand jury transcripts.
Correct.
Okay. So I guess I don't understand how an extradition a year or so after the fact, after the indictments, would have anything to do with the underlying charges. So can you articulate that for me?
I can, Your Honor. There's the detectives that are on these cases are all continuing to go back and forth with all of these different agencies. You have the FBI, you have all the different agencies that are working together. You have Rexburg, Fremont County, you have Chandler and Gilbert. You have all these people.
By the way, no notes here. Just kind of responding back and forth to the judge, making some arguments, trying to get some discovery, trying to get some information that the judge is not letting her get at this point. And while ultimately I do think she's wrong, I don't think she's going to get it. But if she's got some theory she wants to use the extradition information for, maybe some conspiracy against her, how bad they are, the lines being crossed, they don't know what they're doing. They don't know what they're doing in that. So therefore, they don't know what they're doing in my investigation. Probably not going to work as far as relevance goes, but she's actually making an argument and going back and forth with the judge, which I will tell you, you might say that's a low bar, but plenty of people can't do stuff like this, especially in a high pressure situation. Now, maybe the pressure's off her a little bit since she's already in jail for the rest of her life and been convicted of the worst crimes you could ever think of. But nevertheless, it's an interesting back and forth here.
Well, then I have them coming on, they're going to be on the stand and they're going to be in trial and they're going to be saying what they reviewed. They've reviewed all these things. And there's communications between all of these agencies that I feel like that the defense is privy to. We should be able to have that and look at that and see where all this came from, where all this started, why they waited 2 years to make these charges. There's all these things, and why they decided to extradite when I saw someone sent me a news article 3 days before I got brought to Arizona that MCAO was putting out a release that they were not going to pick me up and they were not going to extradite me to Arizona until after my appeals were finished. So it's contradictory to that. I just don't know where it came from. And there's a lot of things that are mystery questions to the defense that we are entitled to according to the law.
All right, well,
A lot of things that we are entitled to. She uses we a lot, which makes me think, reading between the lines, she is getting some help from standby counsel and from her investigator, which there's nothing, unethical about that. they're assisting her as is proper in their jurisdiction, I'm sure. And she says at the end that we are entitled to by law, Your Honor, ending like a proper legal argument. I just found it to be interesting. It also just seems like she wants some answers around extradition, which a lot of defendants would, when we would represent them, they would say, why this, why that? And we'd be like, it's not really relevant to the case. They don't have to turn it over. Maybe we can find out in some of the other discovery or evidence that's presented, but we'll see. But now she's here handling it herself and she's able to ask for anything she wants. And all the judge can do is say no, right? So shoot your shot, shoot or shoot. And it sounds like Lori Vallow is going to try to do that throughout this process.
Well, everything you've just told me, none of that would be relevant in the trial.
That reminds me of the Billy Madison answer. It's like all of that. And I just feel like we didn't learn anything from that answer. A simple no would have, and Billy Madison's like a simple no would have done. He's like, thank you for making your argument, but that is not relevant to the trial. And I tend to agree with the judge here.
In the case in chief, does the state intend on producing any iota of evidence or presenting any scintilla of evidence of anything that happened after the dates of crime that have been charged in the indictments?
The state, although there is information that occurred after that will relate to the conspiracy that has been disclosed to the defense, anything that occurred after the indictment, during the extradition process is completely irrelevant and will not be brought in during the trial.
I didn't mean the date of crime listed in the indictment. I meant the date of the indictment. Correct. So the state doesn't plan on presenting any evidence to a jury of anything after the indictment.
Correct.
So how would that, anything to do with the extradition, be relevant to your trial then?
I feel like it's relevant to the whole, Your Honor, in the sense that the police investigation and the intent of the prosecution, it doesn't make sense. I would like to be able to have that.
The police investigation, the intent of the prosecution, it doesn't make sense. It doesn't usually make it relevant. Now, if she was able to connect it to the investigation, like they were doing something nefarious or they got something they shouldn't have gotten from Idaho, and that's why they extradited her, and the timing gave them some evidence or made it look like a conspiracy when it really wasn't. And, they're trying to add facts or twist something, and the extradition will give me some information on what they did wrong. Okay, then maybe, police misconduct, but it doesn't seem like there's any of that here, at least that she even has a good faith basis to believe happened. So it's going to be tough to tie that in and make it relevant to the trial and therefore making it discoverable.
All right.
It would actually only have to be something that would reasonably believe to lead to discoverable material, and the judge doesn't even see it as that.
Are you otherwise on track for your trial date?
Correct.
Are there interviews going on with your investigator or your advisory council team?
We're working on getting those set up right now.
Okay. Is there anything else we need to address today? This was sort of just a status conference to make sure things are on track.
I have 2 motions that I'd like to file with the court today.
All right. Do you have copies for the state?
I don't today. I thought you could make a copy.
Can we see them?
So she has two more motions that she is handing to the court today that he's going to read, and we'll see. It's just her asking for more discovery, but he gives her a little tip, which I always appreciate when judges do to pro se litigants here, which Lori Vallow is. He gives her a little tip of how to differentiate. So when they reference certain motions, just kind of a inside baseball legal thing here, but good to note.
I'm assuming the 2021 case would be the case that the state intends to try first.
Correct.
How long would that case take for the state's portion to present?
Probably a couple weeks, Your Honor. I mean, and I say that obviously I'm unaware of how long defense will take for cross-examination. So I would probably ask to pre-screen the jury for significantly longer than that.
Meaning 3 weeks or 4 weeks?
Yes, Your Honor.
She's smart to add some time in for a pro se litigant to cross-examine witnesses because you never know what they're going to ask. You never know how long they're going to go. Sometimes things take a lot more time. Sometimes they take a lot less. You just never can tell.
Obviously, I do not know what Ms. Daybell is going to question any of the witnesses.
As we're looking toward that trial date, is advisory council willing to assist the defendant on the jury screening process if we do the electronic questionnaire?
Yeah, so that, yeah. So the
Okay.
extent that we're
All right, good.
going outside of our scope, but yes.
Sure.
She's saying that's even more than we're supposed to do, but we're happy to help. Interesting, right? They seem like they're working as a pretty good team together. Seem like there's workability. I almost said mutual respect, but that's probably the wrong word. I'm just thinking like Sarah Boone or some other defendants that maybe didn't respect their lawyers or weren't appreciative of what they were doing. It seems like Lori Vallow is able to work with hers, even in a standby counsel situation here. And the lawyer's not offended that Lori Vallow wants to represent herself. So it seems, at least from the outside, I should say.
I have received a motion for specific discovery from the defendant. Well, two separate ones. Just going forward, can you title them maybe what specifically you're looking for? Because if you name all your motions the same thing, it gets a little difficult to keep track of them. But I have two separate motions for specific discovery.
Just like discovery.
For example, on this one, you could title it something like motion for discovery related to the Gilbert DR number or something like that, just to differentiate these. We'll make copies of these for the prosecutor and then we'll have those filed with the clerk today. One of your requests was to have the state send you directly any pleadings, which according to their mailing certificate at the back of the pleadings, they are mailing them to you. I can't do anything about how long the jail takes to process that. So I do recommend.
A common argument in basically every pro se case, like I don't get stuff quick enough. It's frustrating. The judge has a bit of a remedy here for that, saying like, we're not going to hold you to the same 10-day requirements. For example, you have to respond to certain pleadings or motions. It's like, we'll give you more time based on when you actually get the documents, which they do for every pro se.
Recognize that there's probably some delays on that, so we won't hold you to the normal reply times because of those delays that it takes getting through the jail administratively. All right.
In that case, Your Honor, could we have perhaps that go to my investigator, then I could maybe get those faster? Can he also be included on that?
Your Honor, I do email them to advisory council as well as in the court, so.
All right.
But there's not much else I can do.
Who's your investigator?
Jeff White.
And your advisory counselor in contact with him? Yeah.
They can be.
Okay. So the record will reflect that the state's getting a copy of those two motions today, and then the state will respond accordingly. I'll just set a I'll have you reply within 10 days of the date of the filing of their response. All right. Depending on and then I'll rule on the motions as they come, or I'll set a hearing if need be. But at this time, I'm going to affirm the final trial management conference of March 18 at 8:30 a.m. in this division.
So it's about 2 months from now. Final trial management conference, as she said, 76 days. So 2 months is 60-ish days. So it's just a couple weeks, a week or two before the trial actually starts. Maybe the trial starts on, not April 1st, hopefully, but right at the beginning of April. Going to be very interesting here to get this one going.
Trial date's currently March 31. Again, the first case that would be heading to trial would be the 2021 case. Anything else for today?
Yes. Will trial be staying before Your Honor? And if so, will we be staying in this courtroom?
I don't know yet. I'm going to confer with the associate presiding judge, and I suspect it will stay here and it will stay in this courtroom, although for jury selection, we may move to a bigger courtroom if we're doing in-person voir dire.
If we're doing in-person voir dire, I'm not sure, like, did they do it electronically? Do they do it by Zoom in Arizona? I'm not really sure about that. That'd be interesting.
Do you know there will likely be the next of kin present? This courtroom obviously does not have a victim room or a witness room. With the media, that obviously makes it more difficult for the state to keep those individuals away from each other, from overhearing each other in this type of case. So obviously, we're happy to stay before this court, but would be requesting that this be reset or moved to the South Court Tower so we would have those accommodations.
State just wants a bigger courtroom. Doesn't sound like a problem.
Talk to the criminal presiding judge and the associate presiding judge regarding that. And it's just a matter of availability of bigger courtrooms. Anything else from the defendant?
I just was gonna ask, can we set both trial dates or how are we gonna do that?
You'll have two separate jury trials with two separate juries.
Correct.
So the first trial that will be on or around March 31st. We anticipate when that trial's done, we'll talk about how quickly we're going to do the second trial. Does that answer your question?
Somewhat, yes.
Okay. It's hard to set the second one without knowing how long the first one's going to take and then the readiness of everyone as far as the second one after the first one concludes. All right, we will be at recess on that matter. I'll take any motions under advisement.
I think this guy might be her investigator. I'm not sure. Maybe another standby counsel. Camera guy turns away. All right. And that's the end of it. She's the original, camera zoomed in on her face too much. That's why we're not going to allow cameras in other trials. And people have cited that. So that's always interesting to watch. So, hey, this actually makes me more intrigued to watch this trial because I think she's going to make it interesting. I think she's going to make some decent arguments. I think she's going to sound coherent, but most of the time jurors get a bit of a vibe when it's a pro se litigant. They very, very rarely win a case. I would be very shocked if she was able to get some little form of success in the trial, but I am intrigued. And you guys let me know, is this what you were expecting? Were you surprised at her ability to at least argue and speak without notes and to read her argument in a way that was prepared and made somewhat similar arguments to what we've heard even lawyers make in other cases? Or is this what you expected based on her background, podcasting, convincing people of stuff, getting a bit of a cult following? Is that not a surprise to you? So from my perspective, it was a little surprising. I don't know what I was expecting, but especially somebody whose competence has been called into question multiple times and their ability to even understand what's going on. I was a little surprised at how she was able to perform here, even with losing arguments. But that's all we got. Till next time, thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a pase you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.